Yes.
My Lord, just to recap where we got to yesterday, my learned friend had suggested to this court that credibility or plausibility doesn't really arise in relation to product claims in the way it arises in relation to second medical use claims. I submitted to you that there was a lacuna in his submissions with respect to claim 7, which has a use limitation, the use limitation being treating a thromboembolic disorder.
But what's the significance of that? I mean, it may be that perhaps slightly paradoxically, the appellant's position is stronger on claim 1 than it is on claim 7. But if that's the case, so what?
Yeah, my Lord, that may be his position, yeah. Indeed. And my Lords, we looked at a...
But the more fundamental question which is raised by this appeal is really what is the position of and what is the role for plausibility in a claim of the kind with which we are concerned in claim 1,
yes,
which is a single chemical compound.
Yes.
And the argument against you, summarising it briefly as I understand it, is that plausibility as a concept which has been deployed by the EPO and by the national courts in the EPC to deal with really 2 main classes of problem. The first one is historically is the problem caused by claims to broad classes of compounds, and the problem there is that there is a gap in the legislation, as is well known. The EPC doesn't provide any ground for invalidity on the basis of what we used to call under the 1949 Act, lack of fair basis. And so therefore, if you are confronted with an overly broad claim, when a narrower claim might be justifiable but hasn't been put forward, you need some tool to deal with it, and plausibility was created in Agrevo to deal with that problem. So that's one scenario. Another scenario is second medical use claims, which are peculiar and gives rise to all kinds of problems in the law. And plausibility is also quite a useful way of dealing with that problem.
Yes.
But the argument is that if you are dealing with a claim to a single chemical compound, then you don't need plausibility because there's no problem of the kind that we have with broad classes or second medical uses. And on the contrary, there's no justification for importing plausibility into that context.
Yes.
So that, in a nutshell, is the argument at its highest.
Yep.
I appreciate, obviously, that Mr. Alexander has variations upon that main argument.
And the difficulty for Mr. Alexander in that is that this has arisen in a number of cases at the European Patent Office. We looked at the Satinib yesterday. We looked at...
That's probably the high point in terms of a single compound, isn't it?
Yes. You've also got, in this jurisdiction, generics and Yeda, which was the
Yeah, but Copaxone is a very peculiar substance because it's not in truth a single compound.
It may not be, but I don't think anything...
It's a mixture of polymers with a weight distribution.
Indeed. So it is a class, but it wasn't that the... And with a lot of... We'll look at Gilead in a minute, but with a lot of these cases, although my Lord is quite right, in some cases, and perhaps Agrevo was an example, where the patentee could have got a narrower claim, in many of the broad claim cases, there was not a plausible middle and an implausible outside. In some there is, but in some there wasn't. And I think in the Copaxone case, it wasn't suggested there was a plausible core, and the problem was the variance as you move outside that. So though my Lord is perfectly right to pick me up on that point, we say it is consistent. And, so, and there is, as my Lord points out, dasatinib. I then wanted to go on and just have a look at Idenix in Gilead.
Sure.
My Lord, there is a sort of additional point, and this is to some extent straying into the respondent's notice, which I don't want to do at this stage, but there is a further point, is that you can have, of course, inventive products. I mean, you may have an inventive material, you may have an inventive device or machine, and there's no reason why in organic chemistry there couldn't be exotic compounds which are inventive per se. You have to, of course, show they're industrially applicable at some level, but where the compound is inventive, the thing is inventive. But as we'll see, and I need to come to some materials, we'll see that that's just not this case. This is a case, and of course it's because it's an Agrevo type case where all that's happened is there's a selection from a known class, and at no point has it been argued that the product per se is inventive. Can I just first, I'll come back to some of these points, my lord. Can I just first have a look at Idenix and Gilead, which is in the authorities bundle, tab 20. And it's very familiar to my Lord, Lord Justice Arnold. This is an appeal from my Lord's decision upheld. And it's worth just, again, it's another example of compound per se claims, although, my Lord, it is correct that there's a class, but it didn't have a plausible core in this case. And I think at 732 of the bundle, you can see the claims. And there was a product per se claim, and then there were also use claims as well. And you can see that. So claim 6 and claim 7. And it was in Marcouche form. And then if one goes to paragraph 105, this is a judgment of Lord Justice Kitchen. As the principles underpinning an objection of this kind were recently considered by the Court of Appeal in Generics and Yeda, the need for the technical contribution is inherent in the problem and solution approach adopted by the EPO. Lord Justice Floyd explained in that case. And then that's set out. I don't need to repeat that, but we can pick it up at 107. It follows that the scope of the monopoly claimed must be corresponded to and be justified by the technical contribution, or put another way, everything falling in the scope of the claim must be inventive. In the case of a claim to a new class of chemical compounds, the selection of those compounds must not be arbitrary, but must be justified by a technical effect, which distinguishes the claimed compounds from any other compounds. Moreover, this technical effect must be shared by substantially all of the claimed compounds. So, my lords, we say that that reasoning applies to, doesn't matter whether you've got a single product or a class of products, the same logic would apply, certainly in those circumstances where it's not being contended that the structure of the product is inventive or its method of synthesis is inventive or something like that. And then we can pick it up at 114 perhaps. In my judgment, the same approach should be adopted in considering obviousness and whether a technical effect is plausible in the light of the teaching and the specification and the common general knowledge. There must be a real reason for supposing that the claimed invention will indeed have the promised technical effect. Again, at 116. Secondly, importantly, it was common ground that so far as compound claims were concerned, inventive steps should be assessed not on the basis that they were just claimed to compounds, but rather on the basis that they were claims to compounds with anti-inflammatory activity, as Mr. Justice Arnold observed, whereas otherwise they would lack an inventive step on the basis that the only technical problem they solved was the provision of additional nucleoside analogue. So although my Lord is absolutely right, this is very much a matter which my learned friend says, well, it's different for single claims, single product claims. There's nothing in the cases or the reasoning to suggest a different approach should be taken when you've got a single claim. And this is an example of a case, as I say, where there wasn't a plausible core and then an implausible periphery. My lords, I wanted to then turn to a supplemental bundle 1, tab 3. And this is my learned friend's opening skeleton below. I just wanted to see how it was being put below. If we go first to paragraph 14, it makes the observation this is not a second medical use case. The invention involves the disclosure of a new compound. In such a case, any functional utility is enough to justify a claim to the compound. Thus, where the patentee states that the compound has a particular biochemical function or effect, here the inhibition of factor 10A, it is entitled to have validity assessed simply on the basis of whether this function or effect is made plausible by the disclosure. It's not necessary to go further and establish whether it was plausible the compound has sufficient potency and or selectivity to be a therapeutic treatment. But it was being accepted at that stage that it did have to show as plausible as a factor 10A inhibitor. And then we can pick it up at 134, so it's just selection, so it's just over the page. My learned friend predecessor sets out under EPO jurisprudence, the objection is seen through the lens of problem solution approach. An invention which does not provide a useful technical contribution cannot be considered to be a solution to any technical problem with the prior art. In the case of a claim to a chemical compound with no technical utility, the only problem to which this could be said to be a solution is the notional problem of finding another chemical compound. This is not a technical problem at all.
And your submission is that that's correct?
That's correct. Under the traditional UK approach, it has long been held an arbitrary choice of subject matter is not an invention. Is the example of the 5.5-inch plate. The mere fact that development is novel and not obvious does not justify a monopoly unless it comprises some form of technical, useful advanced. He then sets out generics and YADA, principles we rely upon. And then at 137, the steps involved in resolving the answer to an agreevo obviousness case are thus as follows. Construe the claim so as to ascertain the monopoly. Ascertain the technical contribution or effect which is necessary for finding inventive step, factor 10A activity. Determine whether the technical contribution or effect is achieved by the claimed products or methods on the basis of evidence, which may include evidence post-dating the patent. I'll come back to that. And then just looking at 140, it's well established that a technical contribution is not considered to lie in the provision of a new chemical compound as such. So it was always accepted, we submit, that this was an agreevo type case. There was nothing inventive in the structure of the compounds per se, taken as they were from a known class. It's not suggested that there was anything inventive in the method of synthesis or anything like that. And although my learned friend is taking the post-priority data point, that's always been before the court, we accept that. Other than that's between us. But other than that, there was very little between us below in relation to the laws, my lords can see from that passage. Now, of course, in some appeals, a new point emerges, a new point of law emerges in the light of the judge's judgment, and perhaps it's been overlooked, or all the thinking gets refined and developed in some way. But that's not this case. Pfizer here now inviting you to adopt a position contrary to that, which they advance below. Now, it's very difficult to pin that case down when it comes to details, but it's that you don't need to apply the test of plausibility with respect to the activity of these compounds. And at least sometimes you don't. I think it's how Mr. Alexander puts it, sometimes you don't. And we understand it follows that this is one of those cases where you don't. That's what his submission is. Now, no explanation has been provided as to why this new case has emerged, other than they lost below and would like another bash. That seems to be the sum total of it. And there were a series of exchanges between my Lord Justice Arnold yesterday with Mr. Alexander, and they start at page 42, line 6. I don't think I need to turn them up. I'm sure my lords will remember them. And my learned friend accepted that in some cases, plausibility would be a relevant question for the claim. And my lord then asked Mr. Alexander, how could one decide whether it was or not? And in the passages that followed, which do bear rereading, they go on for some pages, we say he essentially said two things. First of all, he said, you look at the specification and decide whether it's speculative. At one point, he even used the word credible. And this amounts to a submission that if the specification is on its face credible, you do not need to assess credibility. I mean, it became somewhat circular. And we say, well, that's self-evident. Of course, if it's credible, you don't need to assess credibility a second time. In other passages in that exchange, he appeared to be advancing an ab initio implausibility test. So is it on its face implausible? Inherent implausibility was expressly said to be the wrong test in Warner-Lambert. That is paragraph 30 of that judgment. I showed you that yesterday. So the position we are facing, we submit, is that with authority contrary to his primary position, my learned friend is just saying, well, those cases don't always apply. And in our position has rather unpersuasive ways of putting it, and that this approach has nothing to commend it, in our view. My Lord, the judgment, my Lord Justice Arnold was right to alert my learned friend to paragraph 10.2, I think it is, where the judge makes clear that he's dealing with obviousness and sufficiency together, and he then sets out the legal principles in the judgment from paragraph 26. Now, my learned friend hasn't gone through this judgment hasn't sort of referred to paragraphs, and I wasn't going to do that, but we say that the judge's analysis is right, and we commend it to the court, and I don't understand that any sort of detailed textual analysis is really part of my learned friend's case. My Lord, finally, and it is subject to any question from my Lords, it is the last point, I just wanted to mention HGS. My Lord will recall that was an Article 57 case, not an Article 56 case, not an Article 83 case. It wasn't sufficiency of obviousness, it was industrial applicability. And although there are some parallels to be drawn between all these tests, it's not quite on the same point, considering the plausibility of a claim from the perspective of Article 56. But we submit that insofar as any of the terms in that judgment, like educated guess, are inconsistent with Warner-Lambert, then Warner-Lambert must be the right authority, because it's the later authority where this was looked at. And so we would, this matter has been revisited by the Supreme Court, this area of law, and at least the area of law we're concerned with today has been revisited, and Warner-Lambert must be the decision which this court should follow today. And I didn't anticipate my learned friend was pressing that a contrary position. I think he accepted that Warner-Lambert was binding on him today. My Lord, unless I can be of further assistance.
Well, what do you have to say about G221? I mean, I appreciate that we've had the benefit of written submissions from both sides on the relevance or otherwise of that decision, for which we are grateful. But is there anything you would wish to add orally? I mean, as I understood it, Mr. Alexander really ended up with the submission that we didn't really need to get into G221 in any detail, because he was really saying that the approach he was arguing for was consistent with the domestic case law, and his simple position was that there's nothing in G221 which is inconsistent with that. In any event, he accepted that if Warner-Lambert was applicable to this type of case, then it wasn't open to this court to say otherwise, purely on the basis of G221.
Yes. So, my lord, I should have said that Mr. Tappin's going to deal with G221. Is that all right?
Yes, of course.
I don't want to anticipate his submissions. We hadn't forgotten it. Yes.
Okay.
Sorted out with the lectern. My lords, what I was proposing to do was firstly to highlight certain passages of the application and then take you briefly to certain aspects of W0131. I was then going to look at the case run.
Sounds slightly backwards. Would it not be more useful to look at W0131 first?
Well, my lord, I think. Would you mind if I took that course? Because I think once you've seen once you've seen the application, then it'll be quicker with 131, and we've already looked at some aspects of the application.
Take your own course. Whatever you think best.
Then I was going to look at the case run by BMS below, and then I was going to turn to ground 2 of their grounds of appeal, which is the one I'm really handling, and then I was going to turn to G221 to the extent my lords think that is necessary and appropriate. So the application first, my lords. I know you all have read the section of the judgment in which the judge addresses the teaching of the application. You looked at some of it with Mr. Alexander, but I'd like to just highlight a few aspects, if I may. So it may be helpful to have the application is Supplementary Bundle 2 at tab 1, and it may be helpful also to have the judgment open, because there are certain observations made by the judge as he goes through, which I just want to make sure my lords have in mind. And so the judgment is Core Bundle tab 8, and the section in which he considers the application starts at paragraph 112 on bundle page 128.
Yep.
And so, as the judge noted, the application starts by identifying the field of the invention and then some background, including an acknowledgement of 131 and some general teaching about factor 10A, which was in accordance with the common general knowledge. And then there's one passage in the background I just need to flag up with you for later purposes, which is, my lords will probably have picked up on page 6 of the application, which is page 8 of the bundle. There's a passage, particularly towards the bottom of this page, in which BMS alleged was a disclosure of a particular pharmacokinetic profile, and they said it was a disclosure that that pharmacokinetic profile was possessed by apixaban, and as we'll see, that featured prominently in their pleaded case in support of their position that it was plausible that apixaban would be useful to treat thromboembolic disorders, and that position was supported by the evidence of Dr. Taft. But as the judge said, as we see this in 119 of the judgment, page 130, we see what BMS's case was, and although Dr. Taft stoutly maintained his evidence, BMS gave up on that part of its case, and in fact the judge had said earlier in his judgment that had they not done so, he would have rejected it. And we'll see, this is just one of a number of shifts in BMS's case that have taken place throughout these proceedings. Now the judge then, at paragraph 120 and 121, picks up aspects of the summary of the invention, and that's on page 7 of the application, page 9 of the bundle. And we see, firstly, the first paragraph under the summary of the invention. And we see at the foot of page 7 of the application that the objects which have been set out above, they say, have been achieved by the inventor's discovery that lactam-containing compounds of Formula 1, which is P4PMM4, as defined below, are effective factor 10A inhibitors. Now, we see the definition of P4PM and M4 in further down that page. You'll see there's a square brackets 1 at line 9, and this is the way that the document indicates the different, what we call the different embodiments. And that's, so this is embodiment 1, a novel compound of Formula 1, P4PMM4, and then it sets out what those could be, and it does so over, I think, over 12 or so pages, down to page 21 of the document, page 23 of the bundle. And this embodiment was described by Dr. Redshaw of being of colossal scale. She said it was hard to know how many compounds were covered, but it was at least 10 to the 25. And then we see at the foot of page 21, it introduces the second embodiment, which is said to be preferred. And that stretches through to page 30 of the document. And Dr. Redshaw said this still had an enormously large range of substituents. And then following, starting on page 30, we have embodiment 3, and we can track that through. Embodiments 3 through to 7 are further Marcouche formulae. The judge particularly picked out embodiment 6, which starts on page 63, which Dr. Redshaw said covered at least 49,000 compounds, and embodiment 7, which starts on page 67 of the document, which he said covered at least 2,800. And then embodiment 8, which Arnold and friends directed you to already, which starts on page 68 of the document, and that's a list of 74 compounds, not all of which in fact were within embodiment 7, even though you might have thought that.
I'm sorry, I didn't catch that last bit you said.
Not all of the list of 74 were actually within embodiment 7, even though one might assume that the embodiments are getting narrower progressively, but that in fact wasn't the case. It doesn't.
And sorry, can you enlighten me? What's the significance of that?
No, it may not be important. Just in case my lords thought that they were getting progressively narrower, that wasn't actually fully correct. And my lord, just one point I want to pick up is that as we've going through these embodiments, and it applies to embodiments 2 to 8, and indeed the ones that follow, that all of them are said to be simply said to be preferred. None of them is said to be more preferred, even more preferred, or still more preferred. And I mention that because we'll come to when we come to the language on page 170. And then we needn't look at them, but embodiments 9 to 14 are further Marcouche formulae. And then there is embodiment 15. We needn't turn it up, but that is a list of 124 compounds. So altogether, if you take together embodiments 8 and 15, some 198 compounds are listed in those two lists. And the way that the document works is that those 15 embodiments are then reflected in claims 1 to 15. So the claims are just repetitions of those 15 embodiments. Now, if we then go to, the judge picks up the utility section at 131 of the judgment, and that is page 168 of the document, 170 of the bundle. And as we will see, that opens by saying the compounds of this invention are inhibitors of factor 10A and are useful as anticoagulants for the treatment or prevention of thromboembolic disorders in mammals, i.e. factor 10A associated disorders. Now, on its face, that is an assertion that all of the compounds of the invention, all of those covered by all of the embodiments and the claims, are factor Xa inhibitors and useful as anticoagulants for treating thromboembolic disorders. But as we'll see, I'll show my lords in a minute, at trial BMS did not seek to rely on this statement or others in the general terms that we saw earlier as being credible technical teachings. And one can understand why, given the scope of the number of compounds which are said to be of the invention. Then there's a section from line, at the bottom of page 168, it discusses what a thromboembolic disorder is. And if you turn over the page to 169, it says at line 19 to 21 that the anticoagulant effects of the compounds of the present invention is believed to be due to inhibition of factor Xa or thrombin. And that has some significance when we come to consider the so-called 3-gram point. And then they explain that the effectiveness of compounds of the present invention, inhibitors of factor Xa, was determined using the assay, and we needn't look at the details of the assay. But then at page 170, at line 21, there's the passage with which you will now be, I imagine, familiar. And I'll come back to consider what BMS says about this on the appeal, but just for now, a number of things to note. And firstly is this, that active and effective are equated with having a Ki of less than or equal to 10 nanomolar. 10 micromolar. So in the language of the patent, active and effective mean simply having a Ki of 10 micromolar or less. And as we noted in our skeleton, if you'll note at paragraph 4.
Sorry, can you just help me on this? You say active and effective.
Yes.
So we can certainly see page 170 in the original line 22 use the word active.
Yes. And then at the end of the section, a number of compounds of the present invention were found to exhibit Ki's of less than or equal to 10 micromolar, thereby confirming the utility of the compounds of the present
So line
invention.
31, it says effective.
Yes,
right.
Indeed.
Okay. So you say the message is the same.
The message is the same, and this arose particularly at trial because they've sort of faded into the background, but there were at trial some proposed amended claims, 7A and 7B, and one of them said they wanted to introduce the words wherein the compound is a factor Xa inhibitor, and the other was wherein the compound is an effective factor Xa inhibitor. And I was keen at the outset of the case to know what, we raised clarity issues, and I was keen to know at the outset of the case what it said those meant. And they confirmed, and we've given my lords the references to the transcripts in the bundles if need be, they confirmed that both of those meant having a Ki of less than or equal to 10 micromolar. And so that was all of a piece. It was not, that's what we sort of expected them to say, but it was helpful that they confirmed that was the language of the patent, as it were. The second point I want you just to note is what the judge says about this passage in paragraph 136 of the judgment. So that's page 134 of the bundle. When he says the only statement of work actually done is that the number of compounds were tested have a Ki of 10 micromolar or less. The statements about lower Ki's, preferred, more preferred, still more preferred compounds are aspirational targets. And the statement that the utility of the compounds of the present invention is confirmed is an assertion that an inference can be drawn from the tests that were done. He understood that BMS accepted this, and Mr. Alexander hasn't suggested on this appeal that that is wrong. Now, as we have seen, though, Malone-Friend has sought to make something of these statements about still more preferred compounds of the present invention having Ki's of having nanomolar Ki's. But as the judge said, those were aspirational targets. There's nothing to say that any compounds have been tested and found to have nanomolar Ki's. And this is why I showed my lords that all the embodiments were merely said to be preferred, including the lists of compound names. So there's nothing to link, for example, embodiment 8 to still more preferred compounds. The third point I want to just draw to my lord's attention at this stage is what the judge says in 139, where he says there's no indication in this text itself of which or how many compounds were tested, or with what specific result, and there is no reference to apixaban. And that's obviously right, and he says BMS accepted this. But he's said that the whole picture of the disclosure of 652 must be considered at that general level. I agree. I must go on to consider the other later disclosure and evidence before reaching any conclusion about this passage. And I mention that now, just at this stage, as we're going through it, because one of the criticisms my learned friend has of the judge is that he didn't consider the matters in the round. We say he did, and this is the first indication that he was going to do that. My lords, back to the application. Starting at the foot of 170, there is a reference to a rabbit arteriovenous shunt thrombosis model. And so it's saying the antithrombotic effect of compounds of the present invention can be demonstrated in a rabbit AV shunt thrombosis model. And that, the evidence, well, it's in the CGK document, paragraph 194, if you need it. Actually, that's probably not 194 anymore, if we take 122 off that. I think you've got the new version in your bundles now, which has got the correct numbering in. So I've been told that's gone in.
I certainly received it electronically this morning, for which
okay.
I'm grateful.
Okay.
It hasn't made it, a physical copy hasn't made its way into the bundle yet, but not to worry about.
No, not to worry. We needn't turn it up. But the point to note about this is that there is nothing to indicate that any compounds of the invention had in fact progressed into this animal model. And that is despite BMS's evidence at trial through Dr. Morrissey being that compounds showing promise in vitro would be progressed into in vivo models of thrombosis. And then at page 171, at line 18, it says the compounds of the present invention may also be useful as inhibitors of serine proteases, notably human thrombin, and therefore and various others. And then at 31, it says some compounds of the present invention were shown to be direct acting inhibitors of the serine protease thrombin, and they again set out an assay. And then at line on page 172, at line 17, it says using the methodology described above, some compounds of this invention were evaluated and found to exhibit a Ki of less than 10 micromolars, therefore confirming the utility of the compound.
Beg your pardon, I've lost where you are.
Sorry, I'm on page 172 of the document.
Right.
Sorry, someone coughed. Could you say again what page which?
I'm sorry, 172 of the document, 174 of the bundle it should be.
Right. Yes.
At line 17.
Thank you.
Using the methodology described above, some compounds of this invention were evaluated and found to exhibit a Ki of less than 10 micromolar, thereby confirming the utility of the compounds of the present invention as effective thrombin inhibitors. And as the judge pointed out, that parallels the report of factor 10A inhibitory activity in its level of detail. And again, I draw your attention to that for when we come on to the 3 gram point. Then, as the judge says, a few pages on, we needn't turn it up, but it goes on to discuss non-therapeutic uses. They didn't feature in BMS's evidence at trial, but they decided at trial they wanted to rely on them. We didn't object, and the judge rejected their case based on the non-therapeutic uses, and they don't seek to resurrect that on this appeal. They're restricting their case to therapeutic use. And then, as you'll be aware, we then have the examples which start on page 188, and they go on for over 100 pages. There are 140 numbered examples with synthesis and characterizing data given for 110 of them. And as you know, apixaban is the subject of example 18. And just, I'm sure you're aware of this already, but just the point to note is that these are preparative examples. They give characterizing details for the compounds, including details of the NMR spectra that were obtained, for example, but they don't contain any biological data or any statement that any of the compounds have been tested in any assay. So those were the aspects of the application I was going to draw to your attention, and then I was then going to ask you to take 131, which is Supplementary Bundle 2, tab 3. And if you want also, you can have the judgment, bundle page 151 of the core bundle. The judge deals with it quite briefly, and I think I can do the same. Whereas the application is in the name of BMS, this is in the name of DuPont Pharma, but as the judge records, DuPont Pharma was sold to BMS, and two of the inventors of this document are in common with those of the application, and no doubt that explains the commonality of the approach. So you see, if we turn to 131, there's a similar field of the invention on the first page. And then if you go to page 3 of the document, we see that there are objects set out to find useful factor 10A inhibitors, and you'll see at line 18 to 21 that the objects which have been set out above have been achieved by the inventor's discovery that the presently claimed bicyclic compounds are effective factor 10A inhibitors. So they say here, the statement is, the claimed compounds are effective factor 10A inhibitors. And then we have the preferred description of preferred embodiments. And this follows the same kind of approach as the application in the sense that there are numbered embodiments. And in fact, there are 9 numbered embodiments. And those embodiments are then reflected in the claims, 1 to 9. So when they're talking about presently claimed compounds, they're talking about everything in embodiments 1 to 9. And as the judge noted in his judgment at 235.1, it was common ground that apixaban was embraced within the first, second, third, fourth, 8th, and 9th embodiments of 131. And so this is a case where the prior art discloses a genus from which the patent makes a selection. And as we saw when we were looking, Dr. Turner was looking at generics and IADA yesterday, quoting Dr. Reddy's, in such cases the question is whether the patent not only makes a real technical advance, but also discloses enough to make that credible. And just while we're mentioning the embodiments of 131, the third embodiment, which is one that encompasses apixaban, is described as being more preferred. That's page 22 of the document. See that number 3 is more preferred. And the fourth embodiment, which is page 26, is described as even more preferred. And the utility section in this document is at page 263. It's after the examples in this case. It's page 263, 265 of the bundle. It says the compounds of this invention are useful as anticoagulants for treatment of prevention of thromboembolic disorders in mammals. We've already seen the statement that the compounds are effective factor 10A inhibitors. Now they say they're useful as anticoagulants.
I seem to have a small problem with my bundle. It jumps from page 774 to 866. I don't know where those pages have got to. I seem to be missing them.
I've been working off the one I was always working off. Sorry, what was the? Could you remind me? Sorry, 7.
So those are the bundle numbers. So my copy of WO 131.
Is 774286.
So in the original, I've got 171 and that's, sorry, 173 and that's bundle 774. And on my next page is original 265 and then 8, that's bundle 866. I don't know if my lords are in the same position.
Mine seems to be complete.
Right, it's just me.
There's only one page I think I need.
Thank you very much.
I think the rest of what you're missing, you'll be grateful, is a load of examples. I think that's the page you need.
Which page are we going to?
We're going to page 263 of
263.
the document, 265, sorry.
864.
Sorry. Sorry, 263 of the document, 864 of the bundle.
864.
Thank you.
We saw before, I was showing you the summary of the invention where it says that the claimed compounds were effective factor 10A inhibitors, and now they add at the top of 263 that the compounds in the invention are useful as anticoagulants for the treatment or prevention of thromboembolic disorders in mammals. And then we see the factor 10A assay in the same terms as before. And then if you go to the page, top of page 264, you'll see between lines 3 and 10 the same statements as we saw in page 170 of the application in a different order. So all they've done is they've reordered they've put the first 3 lines of that section came at the end in 170, but otherwise the text is the same. So again, effective and active are given the 10 micromolar cutoff. And then if you then go down to the foot of the page, 264, you'll see some compounds of the present invention was shown to be direct acting inhibitors of the serine protease thrombin. And again, we see that assay described. And at page 265, lines 13 to 16, again, the same text we saw on in the application. Using that thrombin assay, some compounds were the invention were evaluated and found to exhibit a Ki of less than 10 micromolar, thereby confirming the utility of the compounds of the present invention's effective thrombin inhibitors. So, my lord, I think that's all I need out of 131. What you can see is that 131 contains statements that compounds of classes that included apixaban were effective factor 10A inhibitors and useful treating thromboembolic disorders. And no doubt that's one reason why BMS didn't contend at trial that such statements, whether here or in the application, were credible technical teachings. Now, my Lord Justice Arnold asked yesterday about how the patent came to be granted. And we explained this in our skeleton argument trial, which isn't in the bundle, but I'll tell my lords what the position was. It was, I believe it is, what we said there was accurate. The position was this, that the examining division initially found the claims to lack inventive step due to a lack of biological data in the specification demonstrating that the claimed compound solved a technical problem. And BMS's response was to limit the claims to apixaban and to file data, which of course wasn't in the application, showing what the Ki of apixaban was. And the examiner's response was that apixaban was a selection from the compounds in 131, and that no surprising technical effect was shown over the compounds in that document. And what BMS then did was to file Ki data for the compounds of 4 examples of 131. In case you want to know, it's examples 6, 10, 13, and 99, contending that the data for apixaban was better. And it was on that basis that the patent was granted. And so the claims were granted because the specification was supplemented with data which had been missing. And just 2 points about that. Firstly, that in fact, some of the compounds in 131, some of the exemplified compounds in 131, have lower Ki's than apixaban. They weren't that data was not presented to the office, but in fact it's true. We know that from publications, scientific publications by BMS. We pleaded those, in fact, in our grounds of invalidity, Sandoz's grounds of invalidity, core bundle tab 13 for your note, subparagraph L, and those were admitted. So there are compounds within, exemplified compounds within 131 with lower KIs than apixaban. But in any event, of course, we say the examiner was wrong to grant the patent on the basis of later filed data on apixaban, because that effect was not plausible from the application as filed. So, my lord, stepping back, we say there is no teaching in the application that apixaban has a KI of 10 micromolar or less. Even if there had been, of course, that would not have amounted to a technical teaching that apixaban was potentially useful for treating thromboembolic disorders, and that is because, as you know, the judge found that the common general knowledge was that for potential utility in treating such disorders, a nanomolar KI was needed. So, what is the technical teaching in this document regarding the therapeutic utility of apixaban, or indeed any other compound of the invention? There is no technical teaching at all. There is just an unsupported assertion in similar terms to that made about the genus of the compounds in 131. And it's not just that there's no data in respect of apixaban or any other compound in the application. There is no a priori reasoning either. There's no a priori reasoning to support an assertion either that apixaban or indeed any other compound is an effective factor 10A inhibitor, the 10 micromolar level that's put forward, or that it will be useful to treat thromboembolic disorders. For example, there's no explanation of why it is believed that apixaban or any other compound will bind to factor 10A, or why it is believed that it will do so with any particular KI. Sometimes one sees such reasoning in applications based on the structure of the compound, the structure of the target, parallels with structures of other known inhibitors. But there's nothing like that in the application. And to use the words Mr. Alexander used yesterday, the application does not provide any reasonable reasons for expecting that apixaban will be a factor 10A inhibitor, let alone one with any particular KI. Now, as you will have picked up, at trial, BMS disputed the need for nanomolar KIs for potential utility for thromboembolic disorders. Its position at trial was that any KI of 10 micromolar or less, if the compound also had drug-like properties, would be sufficient for potential therapeutic utility. And that was all of the piece with the case it was running at trial, namely that the disclosure of the application made it plausible that apixaban had a KI of up to 10 micromolar. And I want to make that good by looking first, if I can, at BMS's pleaded case. We looked at this briefly yesterday, but I just want to do it quickly, if I may. Core bundle tab 17. And this is their statement of case in respect of plausibility, that they were ordered to serve as a quid pro quo for getting permission to call pharmacokinetic evidence. And after setting out some background and the nature of the application, you'll see at paragraph 6, they refer to some common general knowledge that they say a skilled person would have about crystal structure of the factor 10A enzyme and the structures of known factor 10A inhibitors. And that comes back later on. So they refer to some common general knowledge. They then refer to the assay and how one assesses results in the assay. And then they say in paragraph 8 that although no data for any individualised compounds is provided, the patent and the application each report first that a number of compounds were found to have an inhibition constant of less than or equal to 10 micromolar in the factor 10A assay, and thus are effective factor 10A inhibitors. So again, they're correctly tying effective factor 10A inhibitors in the language of the patent to 10 micromolar. And secondly, and we looked at this as well, the statement, bold statement, that they're effective to treat thromboembolic condition or disease, and that ended up not being relied on at the trial. And then at 9 they say, in the light of the CGK, that's obviously a reference back to the structural matters in para 6, the skilled literacy will consider those statements up to be plausible. So that's a CGK-based case. Then they say at paragraph 10 they refer to example 18 and the gram quantities. And they say at 11 that the skilled addressee would infer from para 10 that apixaban was one of the compounds that had been tested and found to be an effective factor 10A inhibitor. And these are the paragraphs, 10 and 11, the ones which learned friend Mr. Alexander relied on when asked to point to a statement in this document which set out the case now being run about apixaban having a nanomolar Ki. But in fact what is said is that the quantity made leads to an inference that apixaban had been tested and found to be an effective factor 10A inhibitor. In the language of the patent and the language of this document, that's 10 micromolar or less. There's no allegation that the skilled person would infer from the quantity of apixaban made that it had a nanomolar Ki, or even, as my learned friend seemed to be suggesting yesterday, that it had whatever Ki the court found was necessary for a compound to be regarded as a potential utility in therapy. What is said about therapeutic use, potential therapeutic use, is then in paragraphs 12 through to 14. What they say here is, in addition to what we've said before, the skilled addressee will be aware from their common general knowledge that in the case of drugs for treating thromboembolic disorder, certain aspects of the pharmacokinetic profile are particularly important. And they explain what those are. And they say in 30, the skilled addressee will be aware from their common general knowledge that to be effective as a medicament for a thromboembolic disorder, a compound must have not only suitable efficacy, but also an appropriate pharmacokinetic profile. And then they say that the skilled addressee would understand the disclosure at page 6 of the application. That's what I showed you before, a bit about where Dr. Taft was saying it discloses this pharmacokinetic profile. So this is the allegation that Dr. Taft's evidence went to. Understand that disclosure describing a particular pharmacokinetic profile as required for a more effective factor 10A inhibitor. And then they say in 14 that the skilled addressee would understand that disclosure, not only describing a particular pharmacokinetic profile, but as describing an actual pharmacokinetic profile for at least apixaban. And therefore, they say in 15, it would be implausible that it was an effective factor 10A inhibitor and effective for the treatment of thromboembolic disorders. So that's the case that's pleaded about why they say apixaban will be thought of as being of potential utility in therapy. It's having the 10 micromolar Ki plus the particular pharmacokinetic profile they say was disclosed by page 6. But of course that was all abandoned at trial. And so when you take that away, the reliance on page 6 of the application, all that remained was the common general knowledge relating to structural matters and the 3 gram point, which was said to support apixaban having a Ki of 10 micromolar. Now, if my lords would look at their opening skeleton at trial, we looked at this again a moment ago with Mr. Dr. Turner, supplementary bundle 1, tab 3, and I want to sort of pick it up from where Dr. Turner left off. He showed you what they said about the law. I want to show you what they said about the application to this case. So it's supplementary bundle 1, tab 3, and we left it at page 27 of the Bible, and I want to go to page 28. 148. So what they said at paragraph 147 is, so far as claim 1 is concerned, it doesn't require actual therapeutic effects. It's enough to demonstrate some degree of factor Xa inhibition. Valid will provide a new compound which demonstrates some degree of factor Xa inhibition, whether or not it has the necessary characteristics to be taken forward as a drug. And then they say in 148, while the patent actually describes the utility of factor Xa inhibitors primarily in terms of their therapeutic value, it also describes other uses. And these are the non-therapeutic uses which they raised at trial and which the judge rejected. And then they say at 149, the application provides its own test for activity. Compounds are considered active if they exhibit a Ki of 10 micromolar in the assay which is given. That's all consistent with what I was showing my lords, telling my lords earlier. And so, having abandoned the non-therapeutic activities and the judge having found that you need a nanomolar Ki to be potentially useful for therapy, they now have to shoot for a nanomolar Ki, which they didn't do at trial. You can see that here they've been shooting for 10 micromolar. And then if we look at what they relied on in respect of claim 1, if you turn over to page 31 of the bundle, paragraph 158. So, what they're saying is this is what we rely on in relation to claim 1, or why we say it was plausible. And what they're doing here is, they say in paragraph 1, subparagraph 1, you'd make an educated assessment that apixaban would be a factor Xa inhibitor based on CGK, including the crystal structure and the known inhibitors, and that's what we saw in their pleading. And then they say more specifically that the 4-methoxyphenyl group would bind in the S1 pocket of the enzyme, and that the lactam group would bind in the S4 pocket of the enzyme. And then they go on to elaborate on that. And you see in paragraph 4 that includes drawing analogies with the compound DPC423. And then they say in 159, the skilled medicinal chemist will conclude that apixaban might well be an active factor Xa inhibitor, i.e. 10 micromolar. That conclusion would be corroborated and supported by the following facts and matters. Firstly, point 6, that's the so-called frequency of use analysis, which we will, based on documents including the exhibit that my learned friend showed you yesterday. Frequency of use of substituents, and secondly, point 7, the 3 gram point. So, what they're using the 3 gram point for here, consistently with their case, it is to support the conclusion that apixaban might well be an active factor Xa inhibitor, i.e. 10 micromolar. And then if you look at paragraph 164, we're now on page 34 of the bundle, they're now looking at claim 7 and the proposed amended claims. So these are the ones which have therapeutic use in the claim. And what they rely on is, first, what they were referred to at trial as drug-like properties. We see that language picked up in about 8 lines down. Drug-like properties, about lipophilicity, etc., etc. And there's something called Lipinski's rule, which I know my Lord Justice Arnold will be familiar with. What they were doing was relying on their evidence on Lipinski's rule and saying it looks like apixaban will have good drug-like properties. That was their evidence. By the time we got to closing at trial, that had all been abandoned. And so they then say, if a compound had been identified as an effective 10A inhibitor with drug-like properties, and effective, of course, is what they've been talking about, 10 micromolar, then it would be a good candidate because of the role of factor 10A in the coagulation cascade. So for the therapeutic use, what they were relying on was 10 micromolar plus drug-like properties. And then, if we look at the next page, they talk about their secondary case. And the secondary case is their where they bring in the testing. They say, well, you could do your own testing. And we can see that in 168. Is it sufficient, they say, for the patentee to provide a compound which would have been recognised by the skilled reader as plausibly achieving a functional effect known to be associated with a potential method of treatment, when you could then do the tests to determine actual levels of potency and selectivity? And important to note that their case here was, is it plausible that it will have the functional effect? And then if so, you can do the tests. But that, of course, requires it to be plausible in the first place, and we say that is consistent with the law. And then finally, we see page 38, 179, is where they pick up the pharmacokinetic profile of apixaban. That's the page 6 point, Dr. Taft. And that's, as I say, something which all folded and disappeared into nothingness by the end of the trial. So you can see not only from their pleading case, but also from the way they advanced the case in their opening skeleton at trial. They did not put the case on the basis that the application disclosed, or it was plausible that apixaban had a nanomolar Ki. They didn't put the case as Mr. Alexander did yesterday, that it was plausible that apixaban would have whatever Ki the court thought was needed for therapeutic activity. On the contrary, their case was it was plausible that it had a 10 micromolar Ki, and for the purpose of therapeutic use, we can add in drug-like properties or the pharmacokinetic profile. So we can put that bundle away. I was going to go to the judgment. So core 8. Now, before we do this, in our skeleton, you'll just correct the point in our skeleton, we'll quote a passage from a submission by BMS where they say, in effect, this is all a multifactorial analysis by the judge, and we say we agree, and that's why they have to show some error of principle. In case you're trying to find that quote in the documents, that's actually in their closing, not their opening skeleton. That's a mistake in our
Can you
skeleton.
give me the reference?
Yes, it's para 48 of our skeleton, so that's tab 5, the core bundle. Para 48, we say it's in para 36 of their opening skeleton, it's actually in their closing. But the point is what they say there is, of course, right, that it is a multifactorial question to be answered on the basis of considering the evidence in the round. And you'd say that is what the judge did, and why they'd have to show some error of principle in order to succeed on the appeal. Now, if I can go to the judgment on their plausibility case, and that starts at page 138 of the bundle. And what the judge does here is he starts, we see in 153, by identifying the topics to be addressed: plausibility of factor 10A binding, plausibility of therapy, selectivity, non-therapeutic uses. And the first one he's going to address, which is the one that takes longest, is plausibility of factor 10A binding. And what he's identifying here, of course, is BMS's case that the application made it plausible that apixaban was a factor 10A inhibitor. In other words, that it had a Ki of 10 micromolar or less. And he identifies in 154 the aspects of BMS's case, page 170, 3 grams, the frequency of use analysis, the structural analysis, and the availability of simple tests, and which he says is in a category of its own. He deals with it separately. And BMS argued, he says in 1.5 things, that these things taken together mean that 652 makes it plausible that apixaban is an effective factor 10A inhibitor. As he understood it, that was enough for claim 1, they said, but they also relied on being plausible, basically above, that it was useful as a therapeutic for thromboembolic conditions and for non-therapeutic purposes. So you can see that is a correct summary of BMS's case. They said being an effective factor 10A inhibitor, 10 micromolar is enough, also to make it useful as therapeutic. And we, as he then says, we disputed all of that. The particular focus of our case was that the submissions was that the question of plausibility must depend on what was disclosed and not on detective work directed at inferring what data the patent had or might have generated but not included in the specification. And then we also had points about why 10 micromolar wasn't good enough either for therapeutic or non-therapeutic uses. Now, obviously the passages of this judgment which have been focused on the appeal are the those on page 139 about the page 170 teaching, and those on page 140 about 3 grams. And I will come back to those in more detail. I just want to show my lords a bit of the structure of the judgment first. So the next point that the judge deals with is the typical, apixaban is a typical compound. And this was based on Dr. Camp's analysis. The exhibit my learned friend showed you yesterday was his analysis of the compounds in embodiment 8. He did another one about the compounds in embodiment 15. We haven't looked at that, but it doesn't matter. But that's what the judge is talking about in 174. Those two analyses. And we needn't look through this in any detail because what the judge did, having explained what the Dr. Camp had done, is to reject it for the reasons he sets out between 188 and 192. So we needn't go into detail. He rejects that analysis for a number of good reasons, and that's not sought to be revived on appeal. And then he looks at, starting at 193, on the structural analysis. And as we saw, BMS's case was that we could draw parallels between the structure of apixaban and structures of other known factor 10A inhibitors, and in particular a compound called DPC-423, and that gave rise to plausibility. And I don't want to go into much detail, but I do want to just pick up a couple of points with you, if I may. Firstly, just to, so we understand what we're talking about, if you look at page 144 of the bundle, at 197 of the judgment, there's two diagrams set out. There's the structure of DPC-423 and the structure of apixaban, highlighting in different colours the differences between them. And the ones that particular focus was paid to were the differences in the blue bottom left substituents, where apixaban has a 4-methoxyphenyl group, and the differences in the bottom right green substituents, where apixaban has a lactam. And one of the questions that arose, and we see this from 201 of the judgment, was whether it was predictable that the 4-methoxyphenyl group would bind in the S1 pocket of factor 10A and do so in a useful way. And the common general knowledge basis for that proposition was said to be a series of compounds from Lilly. The judge held on the basis, as we see further down this page, that on the basis of those compounds, the skilled person would not regard the 4-methoxyphenyl group as being a successful S1 binder. And then at 206 over the page, when Dr. Camp was asked about the comparison between DPC-423 and apixaban at that position, you'll see what he said. He said it was very, very hard to make a prediction. It wasn't obvious why the 4-methoxyphenyl group would go in the S1 pocket. From a structure-based design perspective, it was very unusual that, as we now know, it did. So I don't think you can really rationalise it, and it was an unexpected finding. And I ask you to bear that in mind, and then we just look at the lactam P4 position was the next issue, and was that a plausible binder? And you see what the quote from Dr. Camp in 208. I asked him you wouldn't be able to make a reasonable prediction. He says, I think it has to go there. It can't go anywhere else. It's hard to rationalise it. I totally agree. But look at the binding modes, you know it cannot go anywhere else. So it has to go in the S4 pocket, and obviously you can test that. You know, this is sort of, in my opinion, well beyond the structure-based design. I think your comments are fair. And the judge says that what that reflects is that based on the later knowledge that the apixaban does bind, one now knows that it must be the case that the lactam group binds in the S4 pocket. But even now it's hard to rationalise. It's well beyond structure-based design. Any possibility that 652 can provide plausibility based on structure is clearly excluded in respect of that group. And the judge then goes on to deal with the point about the rigified core, what Dr. Redshaw's evidence was, which he accepts, accepts Dr. Redshaw's evidence. You see what he says Dr. Camp accepted in 213. It wasn't possible to predict properties. And then he says in 214, the overall position is that the relation to the individual points and their aggregate effect, no prediction based on structure can be made by the CGK, and indeed apixaban's binding is unexpected and hard to explain. And that is, I'm going to ask you to bear that in mind when we come on to matters later, in particular when we come back to consider what, if anything, the difference is under G221. And I'll explain why that is. So, and then what the judge does in 216 is make an overall assessment. And he then takes all the matters together. He says that it doesn't make it plausible to have factor 10A binding the level of 10 micromolar or any useful degree of binding. The fundamental problem is that identified by the claimants. There's simply no, and he's talking about page 170 here, there's no reference to apixaban there to allow an inference that it was one of the compounds for which useful results have been achieved. Frequency of use analysis suffers from the problems above. There's no way to connect any particular compound to any degree of activity. And then he says, importantly, when we come back to the 3 gram point, apixaban had been made in quantity, but that does not mean anything for activity. And the structural arguments fail on the facts. So again, when we come to the 3 gram point, I ask you to remember that how the judge has summarised his conclusion about whether one can tie quantity to activity. So the points fail individually, their whole is no greater than the sum of their parts, and therefore everything fails. No plausibility of any meaningful factor 10A binding. And then he goes on to say, well, in 218, even if it had been plausible that apixaban had a degree of binding indicated on page 170, my findings of CGK, that would be plausibly useful in therapy because nanomolar potencies were needed for that. Then he deals with selectivity, which we needn't look at. Then we have the clear and easy tests point. We've already seen this. At the end of 223, he says, my analysis above means there's not even any encouragement concretely referable to apixaban. And then he goes on to deal with and dismiss the non-therapeutic use points. Now, having lost the argument about non-therapeutic uses and having lost the argument about the KI needed for potential therapeutic utility, what BMS seeks to do is to reposition its case once again and argue that the application disclosed that apixaban actually had a nanomolar KI, something that it never alleged before. And we can, my lords, then go to the grounds of appeal, tab 2 of the same bundle. And ground 2 starts on page 20. And ground 2 is headed implicit disclosure of the application in relation to apixaban. And it's a rather lengthy and discursive paragraphs, but the core of this we can see from paragraph 15 of the grounds of appeal. What they say in the light of what they've set out above is this. Accordingly, the judge should have held that the specification of the application would be understood by the skilled person as containing an implied assertion to the effect that either that apixaban was a factor 10A inhibitor with a KI in the nanomolar range, or alternatively a KI suitable for therapeutic use. And then it says that 16, those two statements, as they call them, are materially equivalent, and being based on an actual test having been carried out, are not bare assertions, but statements reporting and supported by actual, if undisclosed, biological data. Accordingly, each of those two statements render it plausible both that apixaban is a factor Xa inhibitor and that it is one suitable for therapeutic use. So, and then paragraph 17 is to much the same effect. So what they are saying is that it is just as if they had disclosed actual test data on apixaban in the application. And that's what they're shooting for in these grounds of appeal. And that is necessarily so because this is said to be implicit disclosure. And we can see why they're having to contend for an implicit disclosure of a nanomolar Ki, equivalent to actually having set out the data in the document. Because, as Lord Sumption said in Warner-Lambert, it's the disclosure of the application which matters. Or to put it another way, what the technical teaching is. One has to ascertain the disclosure of the document and then ask the question whether that disclosure makes it plausible that apixaban has the utility contended for. We see that in Warner-Lambert, we see that in the EPO cases such as Johns Hopkins. And here they say this implicit disclosure, as they call it, made it plausible that apixaban was suitable for therapeutic use. So,
Do you dispute that latter proposition? If this is implicitly disclosed,
it had a nanomolar Ki.
then it would be sufficient.
Right.
That would be plausible,
Yes.
wouldn't it?
Yes.
Yes.
Yes. The judge,
So the question is, what's implicitly disclosed?
what's implicitly disclosed? Yes, absolutely. No, the judge has made his findings about what you need in order to have plausible potential utility. He said nanomolar Ki is what you needed. We'd also said you need to have selectivity. He rejected that. So yes, that's where the battle lines are. So they need to establish, as they recognise in this passage of their grounds of appeal, that there was an implicit disclosure that apixaban had a nanomolar Ki. And they rely principally on the 3 gram point, which they say has to be taken together with page 170. Now, of course, what the judge has held is that those matters did not amount to a disclosure that apixaban had a Ki of 10 micromolar, or less. So in the light of the judge's findings, how can BMS possibly say that they amount to an implicit disclosure that apixaban had a nanomolar Ki? Now, before addressing what they say in the light of the judge's findings, 2 points. First, that this alleged implicit disclosure is relied on both to support Claim 1 and to support Claim 7. The utility relied on in respect of both claims is the same, utility in treating thromboembolic disorders, and the technical effect relied on in support of that utility is the same for both the nanomolar Ki. There's no fallback position in relation to Claim 1. There were fallback positions in relation to Claim 1 at trial because they had the non-therapeutic uses, but those have now gone. The second point is that, as I've hopefully by now explained, this is not a point that was pleaded or run at trial. What I've shown you is that they alleged that the disclosure was that some compounds of the invention, which they said included apixaban, were effective factor Xa inhibitors, i.e. had a 10 micromolar or less Ki. And the fact they said that apixaban had been made in gram quantities indicated that it was an effective factor Xa inhibitor, i.e. less than 10 micromolar. They relied on the frequency of use case, the structural case at the same end, and for Claim 7 they added in the drug-like properties and the pharmacokinetic profile, both of which fell away. So we say this is a case that they didn't run below, and you'll see we've quoted in our skeleton, you can turn it up if need be in tab 9 of the core bundle, what the judge said when he was asked to grant permission to appeal in relation to this. And this is page 210 of the bond, paragraph 12. And I'm not going to read it all out, my lords. We put it in our skeleton. I'm sure my lords have read that, and I invite you to read it again if need be. But it's absolutely clear the judge was clearly of the view that this is not a point that was run at trial. And he recognised what's happened here is that once he'd found that an animal KI was necessary for therapy, something which they're not challenging on this appeal, they're trying to re-aim its case at a different implied assertion and a more ambitious target, which was not raised before. So that, he makes it clear that, for your benefit, I think, his view that this was not a point raised at trial. And we say that's clearly right, for the reasons I've been through. And we say they shouldn't be permitted to raise it. And Lord Justice Arnold asked about the cases on this, and I've brought along what I believe to be the correct case. Hand it up, perhaps.
Which one is it?
Notting Hill.
Well, maybe I've got the wrong one.
It's
Notting Hill
Notting
Finance
Hill,
and Shake.
Yes. As certainly one of the leading authorities in this area.
Now, if I can ask you to go to page 5 of the report, you'll see there's a heading, was the judge correct to allow the new point to be raised on appeal? You see, I'm sorry, I'm just trying to remind myself who this is. This is Mr. Justice Snowden sitting in the Court of Appeal, with whom Lord Justice Peter Jackson and Justice Longmore agreed. And we can see at paragraph 23, he says, he refers to the most authoritative and frequently applied statement of the approach of the court. And that comes from Lord Justice Norton Tallis. The rule, he says, this is right at the bottom of the page, if a point was not taken before the tribunal, which is the evidence, an evidence could have been induced which by any possibility would prevent the point from succeeding. It cannot be taken afterwards. You're bound to take the point in the first instance so as to enable the other party to give evidence. Then he goes on to consider where the point is a pure point of law, which we needn't look at in detail. And then 24 interlocutory decisions. And then 25, or Justice Hatton Cave in Singh and Das. And we see that, the appellate court will be cautious about allowing a new point to be raised on appeal that was not raised below. And the second, an appellate court will not generally permit a new point to be raised on appeal if that point is such that either it would necessitate new evidence, or B, had it been run below, it would result in the trial being conducted differently with regards to the evidence at the trial. And then again, he goes on to look at pure points of law. So 26, these authorities show there's no general rule that a case needs to be exceptional before a new point be allowed to be taken on appeal, whilst an appellate court will always be cautious before allowing a new point to be taken. The decision whether it's just to permit the new point will depend on analysis of all the relevant factors. These will include in particular the nature of the proceedings which have taken place in the lower court, the nature of the new point, and any prejudice that could cause the opposing party if the new point is allowed to be taken. And at one end of the spectrum are cases such as Jones, in which there's been a full trial involving live evidence and cross-examination in the lower court, and there's an attempt to raise a new point on appeal, which, had it been taken at the trial, might have changed the course of the evidence given at trial, and or which would require further factual inquiry. In such a case, the potential prejudice of the opposing party is likely to be significant, and the policy arguments in favour of finality in litigation carry great weight, etc. And then 28 is the other end of the spectrum, which is not this case. So, my lords, we say, in fact, interestingly, my learned friend's response to this objection on our part was not to say that if the case was a new one, they should be allowed to run it. His response to say was that it wasn't a new case. And that's why I spent some time going through it and showing my lord what the cases that was run, and it's clearly different to the one that's being run now, as the judge recognised. But we say, learned friends say has not suggested otherwise, that this clearly falls within the category of cases which should not be allowed to be run on appeal. If they'd wanted to run this case, they should have told us, firstly so that our witnesses could have addressed it specifically, and indeed they should have put it specifically to our witnesses. They should have put it that it could be inferred that apixaban had a nanomolar Ki, or as they now want to put it, that it could be inferred that apixaban had whatever Ki was needed for potential therapeutic activity. And they should have told us so that we could consider what else we needed to address in cross-examination of their witnesses. And it's always hard to know quite how one would have conducted the case differently, quite what questions one would have asked differently, but there would have been additional matters we could address with their witnesses. For example, we could have spent time with Dr. Camp examining potential quantitative differences between the KIs of DPC-423 and apixaban, because while it was common ground, and indeed it's in the common general knowledge, agreed common general knowledge, that in medicinal chemistry, small differences in structure can have large and unpredictable effects on activity, there was actually some specific evidence that of differences in activity between factor 10A inhibitors. This was some evidence from Dr. Redshaw, which were much smaller differences, structural differences, than those between DPC-423 and apixaban, had led to over 1,000-fold difference in activity. Now, I didn't need to get into that with Dr. Camp, because the quantitative point wasn't being taken. It wasn't being said you were predictable that it had a nanomolar Ki rather than just some base level Ki. So, my lord, we say that they shouldn't be allowed to run this on appeal for those reasons. But we also say that
Can I, just before you move on, check that I've understood this correctly. That what a document means is in the end a matter for the court.
Right.
But a document like this is addressed to a person, skilled person. So
Right.
you do need evidence from experts as to how the document will be understood by.
Yes.
It's not a pure point of construction for the court
There are
to look at untutored.
absolutely. There are two ways in which it comes in. Firstly, where the question is one of implicit disclosure, then clearly you have to read it through the eyes of the skilled person.
Yes.
It's not, you can't just look at the words on the page. You've got to say, well, what can one in fact infer as a matter of implicit disclosure? And that is something for which where evidence is clearly going to be important, because you're viewing this not through the eyes of a chancery lawyer, but the eyes of a skilled person. And secondly, the question of plausibility, what does the disclosure make plausible, is clearly something on which evidence is admissible and indeed necessary.
But you don't need that latter step because the battle line is simply the implicit disclosure. You accept that if it is implicitly disclosed that it had a nanomolar effect, then that would be plausible.
Right. Yes.
Yes. Your point is you can't ask the judge, and so you can't ask this court to decide what's implicitly disclosed without evidence.
Indeed, without evidence going to the specific point that is now sought to be run.
And that's all you need to say it's an evidential point, so the evidence would have been different.
Yeah. But, my lord, we say in any event, the judge's findings of fact are quite sufficient to defeat the new case. Now, can I show, my lord, why that is? So, back to the judgment in Core Tab 8. And I'm going to deal first with the disclosure of page 170.
Just before you make this point, is this a point the judge himself made when refusing permission to appeal? I just read what he said. He said that the attack on his paragraph 172 was artificial. He didn't explicitly say my findings in 172 are sufficient to defeat this case in any event.
Sorry, you're referring to
This
something in
was
the judgment? Permission to appeal?
the judge, you've referred us to paragraph 12 on
Yes.
page 210.
Yes.
And then he said that's one difficulty with ground 2, namely that
Yes.
it's not the case that was run before him. And then he went on to say, in paragraph 14,
Yes.
that this ground relied heavily on a selective and incomplete treatment of what he had said in paragraph 172.
Right. Yes, paragraph
I think
172
you're
is...
slightly going beyond what he himself said.
Yes, I think paragraph 172 is when we come to, it's on the 3 gram point, so I will come to that. I'm not sure that my learned friend put it yesterday in quite the same way it was being put before the judge on the permission to appeal hearing.
No, I mean, you're not bound by what the judge says.
No,
if the judge didn't say it, doesn't mean you can't take the point.
Yeah.
I was just trying to get the black lines clear.
I think perhaps maybe having seen what the judge said, the emphasis has slightly shifted on the friend's part. But so I was going to go, if I may, back to page 139 of the judgment and deal first with what the judge said about the teaching on page 170, and then come to the 3 gram point. So we can find the text of page 170 either in the application, if need be, or in the judgment back at 135. Both of them have it. I took you to what the judge said about this passage, this paragraph on page 170, back back up. I've already taken you to page 134 of the bundle, where the judge quotes the relevant passage from page 170 and makes a number of observations about it. I showed you that already, and I asked you just to bear those in mind. I'm not going to go back to them other than just say they were there and I rely on them. Back on page 139 of the bundle, where he starts to address the teaching on page 170, the first point he makes is there were these very general statements about bare use assertions of utility, which BMS accepted were not good enough. And I showed my lord some of those in the when I went through the application. There's the start of the passage on the utility section on page 168, for example. And that's why the focus fell on the sentence at page 170, lines 28 to 32. And what BMS submitted, that you assume that all of the synthesized compounds have been tested, but importantly accepted in 160 that the skilled reader would infer that not all the compounds tested would have been successful, some might have failed. And that's important because it cannot be said on that basis that the skilled reader would assume that there had been success with all the synthesized compounds. And then in 161, he says that BMS seeks to read far too much into it. On its own, it wouldn't be understood as standing with any reliability for anything more than it says, which is that some unidentified compounds have been tested with activities at the level indicated, and that utility for some broader class, i.e. than just the ones tested, could in the patentee's opinion be inferred. What that broader class might be cannot be worked out for the reasons he gives. And then further, he says in 162, there's no way from the sentence alone to draw any sort of inference about any individual compound, be it apixaban or any other. There's simply no information, and given counsel for BMS's acceptance that some compounds might have failed, there is no way for the reader to know of any particular compound, whether it was good or bad. And we commend that completely to my lords. What do they say in response? Actually, just before leaving the judgment, it's important to note on 163, to be fair, I don't think that BMS really seriously maintained a case that the disclosure on page 170 was enough on its own. It therefore sought to tie it to apixaban, by means to which I will now turn. So, and I ask you to note that because of the criticism from my learned friend, the judge has taken all of the different points in isolation. Not so, we say. He was well aware that they needed to be taken together. So what do my learned friends say in response to what the judge says here about the teaching on page 170? Well, they rely on the statements about more preferred or still more preferred compounds. But we say that doesn't help BMS because there's no indication of which compounds were tested and what results were obtained for those that were tested, other than that some had a Ki of 10 micromolar or less. And there's no indication that any compound had any particular level of Ki other than being 10 micromolar or less. And there is, in any event, no reference to apixaban. So merely referring to the aspirational statements about, well, still more preferred ones would have nanomolar Ki cannot help my learned friend, because there's nothing to tie any such statements to apixaban. Indeed, there's nothing to indicate that any compounds were tested and found to have a nanomolar Ki. So that's the first point they make. And the second point they make is simply they say, well, the judge failed to consider page 170 together with the other aspects they relied on. And we say that's unfair. I've already shown you in 139, he accepted that you had to consider the whole picture of the disclosure of the application. You had to go on and consider all of that before reaching conclusions. He says in 163 that he was well aware that BMS were trying to tie this statement to apixaban. And in 216 to 217, which I've also showed you, is where he looks at all the factors together and makes an overall assessment. So we say there's nothing in that point. But in any event, the only matter which they seek to add to page 170 is in fact the 3 gram point. So I need to then turn to consider that. And we see the judge starts to do that at 164. And he accepts that 3 grams was made, that was the most of apixaban, that was the most of any compound reported to have been made by some distance. And it was 3 grams as opposed, I think the next one was somewhere between 400 and 500 milligrams. And he accepts in 171 that the skilled reader would notice that. So those are matters which he found in favour of BMS, but nonetheless he says he rejects their case. So in 166 he says there's no explicit disclosure of why the patentee made that amount. And then he goes on to consider what BMS was saying. BMS said that the reader would infer it's because earlier results were favourable and the patentee wanted to take work on the compound forwards. Now, sorry, just stepping back before looking at that. Of course, what the judge is doing here is considering whether it's possible to draw, whether an inference can be drawn that, which would support BMS's case that it was plausible that apixaban had a Ki of 10 micromolar or less. And now, of course, they're aiming for an implicit disclosure of nanomolar Ki. But we say the reasons for rejecting that, for rejecting BMS's case that we're running at trial, are equally good for rejecting the implicit disclosure of nanomolar Ki. So, going back to 166, BMS said you'd infer that it was because early results had been favourable and the patentee wanted to take work on the compound forwards. And
so, can I see if I've understood that correctly? Because I put a point to Mr. Alexander, which he said took him by surprise, but this was the sentence that I had in mind. Because it's recited here that it was BMS's argument for the judge. The reader would infer that it was because early results had been favourable. Now, upon analysis, what that must mean is that 2 things are being inferred by the reader, even though they're not expressly stated. 1 is that there is a prior synthesis, and 2, that there's been testing of the prior synthesized material.
yeah, that must be right.
Mr. Alexander jibbed at 1, but how can you have 2 without 1? You can't test something you haven't made.
Absolutely right. At least no one's thought of a way of doing that yet. But
Yeah,
AI
well,
is working
subject
on
to
it.
AI.
Yes.
We'll come to that in a later case. Yes.
I think it's a matter of logic. It must be right. It's what they're asking the judge to accept by way of an inference. But what the judge then says is the evidence of the DMPK experts, that was Dr. Taff and Professor Reed, was that this was possible, with the further work intended being possibly second species pharmacokinetics or early toxicology. Now, in my learned friend Skeleton, I don't think he really advanced this point yesterday, but he wants to read this paragraph as saying the DMPK expert said that it was possible to draw the inference. That's not what the judge is saying at all. He's saying their case was that you could make the inference that early results had been favourable. The evidence of the DMPK experts was that this was possible, with the further work being what it is. In other words, what the DMPK experts are saying is that it's possible that early results were favourable and that they wanted to take the work forwards. He's not saying that it's possible to draw the inference, and that would have been inconsistent anyway with the evidence of Professor Reed. The furthest he went was to say that one could speculate the initial pharmacokinetic work.
So in other words, your submission is that the use of the word possible in the fifth line means a possible reason or a possible explanation.
Yes, exactly. And one could see that this was possible with the further work, the patentee wanted to take work forwards, with the further work being whatever is what is said there. They're not saying, certainly Professor Reed didn't say, and the judge couldn't have been suggesting that he did, because all he said was, well, one could speculate that initial results were promising, but then one would want to ask why no results were reported. So that was his evidence. But clearly that's what the judge is saying, is that it's not that it's possible to draw an inference, but this is a possible explanation. And one can see that that must be what the judge is saying from the rest of his judgment. Because he then says in 167, we responded, there are other possible reasons, making an intermediate or as a thrombin inhibitor, which seems possible given the teaching of 652 on that topic, if not especially. And that's why I showed you the passages in the application about thrombin inhibition, that they were saying that the anticoagulant effect could be due to factor 10A inhibition or thrombin inhibition, and that they had tested some compounds and found them to have a Ki in the thrombin inhibition assay of less than 10 micromolar, which they said showed that they were effective thrombin inhibitors. So, given the teaching, as the judge says, that is a possibility given the teaching of 652. And once one admits that there is a possibility that the reason the patentee had made 3 grams was something other than positive results in a factor 10A inhibition assay, then there can be no implicit disclosure. Because it is not then, as if they, which is what they say in their grounds of appeal, as if we had written the data down and put it in the patent. Once you say, well, there's more than one credible explanation for what they have done, there is no implicit disclosure that there's a nanomolar Ki.
It doesn't matter how relatively possible, which is more likely. Because Mr. Alexander said, well, these our possibilities are fairly remote.
Doesn't matter, we say. I mean, there may be cases, borderline cases, where you can say, well, the possibility is so absurd that although it's theoretically possible, as a practical matter, I will rule it out. But where there are real possibilities other than factor 10A inhibitory activity,
And you can't infer.
you can't infer.
In the absence of some other factor.
In the absence of some other factor,
And all
which
the other
tells you
factors
that
by this stage have been ruled
yeah,
out.
if you've got a number of options on the table and something else tells you it's this one, then fine.
Yeah,
That's
you've got to have a reason for choosing one
got to-
possibility
you-
over the other.
exactly, and you haven't here.
Can I be sure I've understood this point of yours, that you can't infer anything from the 3 gram point? It's not only a separate point to there's no disclosure that anything had nanomolar properties. But even if you were wrong on the 3 gram point, and that you could infer that early results have been favourable, all that would enable you to infer was that apixaban was one of those compounds that have micromolar.
Yeah, well,
Activity.
you see, this is the problem. It all depends what you mean by favourable. And of course, they were only having to show that it was, they were only aiming for 10 micromolar.
Well, all that page 170 says is some things have micromolar activity.
Absolutely, yeah, absolutely. I agree.
So what they need, if you're right on this, what they need to show is not only does the 3 gram point enable you to infer that early results were favourable, but the favourable early results had nanomolar activity, not micromolar.
Absolutely.
So they are cumulative points.
Yeah. I agree, my lord, yes. So that's the first thing, thrombin inhibition. Then we have Dr. Camp. Now, in his report, Dr. Camp was quite careful. He said that the quantity made can be an indicator of successful results. And I put it to him in cross-examination. This is what you say, and he said it can be. And then I showed him this document that the judge refers to, this paper by Scott Sheehan of Lilly. It's a Lilly publication where they're making factor 10A inhibitors. And what they'd done, we had the document, I think we had a patent application as well, which showed you that they'd made large quantities of a particular compound, which actually had a Ki that was nothing like nanomolar. So I said to him, I put to him, well, this shows you people make large quantities, gram quantities of materials that are not anything like, they're sort of, I can't remember what it was now, I think it was 717 nanomolar or something. It was just under 1 micromolar or something. I can't remember the actual number. And what he said, as the judge records, he says, well, the amount of a compound could not be taken as an indicator of success in every case. One possibility was just that the chemistry worked better. And so that's another possibility. And it doesn't mean you can't infer success, in other words, success in the factor 10 inhibition assay, from the amount of compound made. And then 169, the point that was being made to Dr. Camp here was, well, there were lots of review documents in the case, which the experts all commented on, and there were well-known review documents in this field. But nowhere in those documents had someone gone to a patent application, because they were reviewing patent applications, and said, this one's been made in high levels, large quantities. I can work out from that it must be the one they're interested in. So no one was using this as an indicator of quality. Dr. Redshaw maintained her position that judgments couldn't be made about a compound's quality to the amounts made. And then there's the point about 171 where he explains it's relatively free of hindsight. But it's a very weak point, the judge says. Lacking any data, one doesn't know why the patentee made such a quantity, and reasons other than factor 10A inhibitory activity are real possibilities. And that's why you can't draw the inference. And that's why the judge says, when he comes to his summary in 216, he says, and I showed this earlier, apixaban have been made in quantity, but that does not mean anything for activity. In other words, one cannot draw the inference. And there's he also said in 223, there's no encouragement concretely referable to apixaban. Clearly he's finding that you can't make an inference about the activity of apixaban from the quantity that was made. And it follows, we say, that on the judge's findings of fact and assessment of the evidence, we endorse what Lord Justice Arnold said yesterday, that in his findings here, his summary finding in 172, one doesn't know reasons other than factor 10 inhibitory activity are real possibilities. What the judge is doing there is making an assessment of the evidence which he has heard. And the multifactorial assessment, which we say cannot be interfered with on this appeal. And so there can be no implicit disclosure of a apixaban having a nanomolar Ki, just as there's no implicit disclosure of apixaban having a micromolar Ki. And there's the additional problem, which is that what does favourable mean? Especially in a context when people weren't focusing on nanomolar Ki's. Now, what my learned friend kept saying yesterday was one could make a reasonable inference that the patentee made 3 grams of apixaban because early results had been favourable. But the judges explained why such an inference cannot be drawn. What Mr. Alexander was really saying, though he used the language of inference, was that one possible reason for why 3 grams had been made was that apixaban's early results were promising. But that's not part of the disclosure of the document. That's not implicit disclosure. That's just identifying possibilities and guessing. And as Lord Sumption said in Warner Lambert, the disclosure of a possibility is not enough in any event. Now, just to finish this off, in 172, the second half of it, what the judge is saying here is that the highest it could be put on the basis of this 3 gram point is that the patentee thought apixaban was interesting, promising. And he's making a point that an express statement to that effect would have been no more than a bare assertion, so an implied statement to that effect could be no better. And as my lord has picked up, this is the point that is then being commented on in paragraph 14 of the judgment on permission to appeal, because at least at that point, BMS were trying to spin what the judge said in this paragraph in a way that the judge obviously thought was not sustainable. So, my lords, we say the judge was fully entitled to reject the case run at trial, that one could draw an inference to support BMS's case. It was plausible that apixaban would be a thromboembolic treatment. And accordingly, the new case, which is that there's an implicit disclosure that apixaban has a nanomolar Ki, must also fail. And my lord, we say that is the end of ground 2 of the appeal. Now, I was then subject to any questions from my lords on that area of the case. I was going to turn to G2 of 21.
Could I just ask this? What has to be proved to establish the implicit disclosure? Is it that the skilled person would probably, on the balance of probabilities, read the specification, or in this case the application, as disclosing whatever it is that is asserted? Is that the test? The patentee has to prove on the balance of probabilities that is what the skilled person would draw from it.
It probably depends on that, where you insert the balance of probabilities into that question. If you see what I mean, all assessments that the courts make as to evidential matters are ultimately determined on the balance of probabilities. That's what the judge is making. He's making findings. He has to say, what do I think is likely on the balance of probabilities? But within that, he's making a find. What he has to determine on the balance of probabilities is what would the skilled person think. It's not. Do you see the distinction I'm trying clumsily to draw? I think.
Well, if the question is what interpretation would the skilled person place upon the specification? That's an easy concept to understand.
Yes.
What meaning would the skilled person take from it? Now, I don't know in this context whether there's a range of meanings that you can consider, or whether you have to take one meaning. Normally, in the interpretation of documents, it is only one. Whatever might really happen. The document presumably has a meaning.
Yes, and as my Lord Justice Nugee pointed out earlier, the meaning of the document is for the court.
Yes.
But as I understand your submission, what you're saying is that in the present case, it's not a question of interpreting the words of the document. It's a question of whether you read in something which is not said.
Yes.
And that depends upon the factual matrix, namely, what are the possible explanations for what is said? If there is only one possible explanation for what is said, as a matter of fact, then obviously you read that in. as I understand your submission, what you're saying is that the judge has found as a fact that there are other possible explanations which would have occurred to the skilled person.
Yes.
He makes those findings of fact on the basis of the expert evidence on the balance of probabilities.
Yes.
Having made those findings of fact, he then interprets the document.
Yes.
And the interpretation would be reviewable in principle by this court, because the interpretation is a matter of law, but your submission is that goes nowhere, having regard to the findings of fact.
Absolutely.
And indeed it goes further, because as you said earlier, this is a new point and the evidence would have been different, or might have been different, and therefore you can't even get into the question.
That's right. So, my lords, G2 of 21.
Yes.
Now, we've put in a summary of our submissions on G2 of 21. I was proposing to elaborate on that orally, and we can discuss how much my lords want me to do. But as you'll have seen, BMS's written submissions on G2 of 21 say very little. They just say that it provides some indirect support for their position. Yesterday, Mr. Alexander didn't take you to the decision itself, but what he did submit was that it had dethroned plausibility to a degree, is the way he put it, and that the enlarged board had taken a completely different line to either ab initio plausibility or ab initio implausibility. He didn't submit that Warner-Lambert was not binding on the court as a result, but what he did submit was that Warner-Lambert was confined to second medical use claims, and we dispute that for the reasons Mr. Turner has been explaining to you. What he didn't submit, what Mr. Alexander didn't submit, was that the court was not bound by its previous decisions in Idenix and Generics and Yada, which are also product claim cases. And he did not suggest that this was a case for the application of the exception to the rule in Young and Bristol Aeroplane, which was identified in Activis and Merck, where I know my Lord Justice Arnold will be familiar with this, but in that case the Court of Appeal expressed the view that there should be a further exception to the rule in Young and Bristol Aeroplane, where a settled practice of the EPO was clearly inconsistent with Court of Appeal authority. But my learned friend has not suggested that this is a case for the application of the exception to that rule. In order to do that, of course, you would have needed to say that the decision of the enlarged board was clear in his favour and inconsistent with the previous authority of this court. And I can only assume that he didn't feel able to make that submission, which one might think is slightly odd, because next Wednesday there's a hearing of a renewed application for Sandoz, for a PI, preliminary injunction, against my clients in the Hague court. And in order to renew, as my understanding is, in order to renew an application for a PI which was previously refused, as it was, BMS need to show a change of circumstances. And what they say is that whereas previously the Dutch court applied an ab initio plausibility approach to give weight to the decision of the judge in this case when considering its judgment on that application, they say the law has changed as a result of G2 of 21, with ab initio plausibility being swept away and being replaced by a much less strict test. So that in the Netherlands, they say that there is a Court of Appeal, the enlarged board clearly has come to a clear view contrary to that which has been applied in the Dutch courts and in this court previously.
Well, Dutch lawyers are well known for their creativity.
Anyway, so my clients are faced with BMS making such a submission to the Dutch court that G2 of 21 represents a radical change in the law, but without making such a submission in this court, or whether that's for tactical reasons, we don't know. But what Mr. Alexander's submission amounted to yesterday was that, as he said, it has taken the enlarged board has taken a completely different line and dethroned plausibility. Now, in essence, we say that while the enlarged board has chosen to use different language, there is no difference in substance, and that the considerations which are relevant when considering whether a product claim can be justified by an alleged technical effect remain the same. And I was planning to elaborate on that by reference to the decision, and I think I'll keep going until I'm stopped. Is maybe the right.
Look, it's something that we clearly have to take into account.
Right. Well, can I start then? I think for helpful context, to look briefly at the referring decision, which is third bundle of authorities, tab 25. So the referring decision, and can I ask you to go in the bundle to page 1146, section 13, is need for the referral question. And they say there's a fundamental question of law for which diverging lines of case law exist. Now, then at 13.2, they talk about the problem-solution approach. Now, one finds slightly different formulations of this in EPO case law, but whatever formulation one goes to, one sees certain commonalities. Firstly, you have to identify the closest prior art, which we see this on page 1147, which may not necessarily be the one mentioned in the patent in suit or envisaged by the patent proprietor. And then you compare, make a comparison between the subject matter of the claim and the disclosure of the prior art and identify the difference. And then you have to determine the technical effect linked to the difference, and then formulate the objective technical problem, which is, i.e. the problem which can be seen to have been actually solved in the light of the closest prior art. And that technical problem is essentially achieving that technical effect. So the technical problem is solved is the actual achievement of the alleged technical effect linked to the difference between the subject matter of the claim and the disclosure of the prior art. Now, they haven't concluded it, but obviously there is a further step, which was it obvious for the skilled person seeking to achieve the technical effect to make the step between the prior art and the claim. And then I think it's important to notice this in the passage that follows the bullet points. They say it's often necessary to provide post-published evidence as proof that the problem has been solved, i.e. the alleged technical effect is actually achieved. This applies in particular when the objective technical problem has to be reformulated, e.g. with regard to a closest prior art document previously unknown to the patent proprietor, which is obviously not this case, because 131 was clearly known to the patent proprietor and cited in the patent in suit. But this issue of reformulating the technical problem for assessment of inventive step in the light of new prior art is something that has to be addressed by the EPO when applying the problem-solution approach. And that is actually something to bear in mind when we look at what the enlarged board says, because it actually underlies a lot of some of the discussion by the enlarged board. Now, in the UK, we haven't adopted the straitjacket of the problem-solution approach. We tend to approach obviousness by using the structured approach using POP solely, but we also recognise the fundamental principle underlying the law of inventive step, as well as that of sufficiency, namely that a patent monopoly should be justified by a technical contribution to the art disclosed in the patent, and that a technical contribution does not lie in merely providing a new product, whether it's a new chemical compound or a 5.5-inch plate, but in disclosing some new useful technical property of the new product. And without such a useful property being disclosed, there's no invention. And that's what we see underlying Agrevo in the cases in the UK which have applied it. And we can see that in the problem solution approach, because if there's no technical effect, then there's no objective technical problem to be solved. And so you end up in cases like Agrevo, where patentee said that the technical problem was providing compounds with herbicidal properties, but that could not be seen to have actually been solved. And what could be seen to have been solved was the provision of further chemical compounds, which is inherently obvious. Now, over the page, we see that there are, sorry, at the foot of the page, they say that in their view there are three diverging lines of case law. And they make the observation at 13.3.1, whether D21, that was the post-published document, can be taken out arose in the case at hand in the context of inventive step. But in other cases, it arises under the heading of a sufficiency of disclosure because the effect is expressed in the claim. And what they say, while that affects which provision of the EPC applies, doesn't, in their view, have an impact on the considerations applying to the above issue, and therefore they're going to deal with decisions not only under Article 56, inventive step, but also Article 83, sufficiency. And they then identify the three lines of case law that they perceive. And we see that 1149, 13.4, ab initio plausibility, and they characterise that as ones where you can only take into account post-published evidence if, given the application is filed in the common general knowledge, the skilled person would have had reason to assume the purported technical effect to be achieved. That's their summary of that line of case law. And in this, as they say, that can be experimental data or a scientific explanation. And they cite, there's cases in this line, firstly, T1329 of 04, that's Johns Hopkins. Then Salk, that's on page 1151. And then on page 1152, T488 of 16, which is dasatinib. Then at 1153, they've got the second line of case law is ab initio implausibility, and they say that's ones where post-published evidence can only be disregarded if the skilled person would have had legitimate reasons to doubt the purported technical effect would have been achieved on the filing date of the patent in suit. And they explain how such doubts may arise. And those cases, there are a number of cases, but one of them they cite on page 1155 is T578 of 06, which is Ipsen. And then finally at 1159 of the bundle, 13.6, there's a third line of case law which they say seems to reject the concept of plausibility altogether. And they give an example. This is a much less populated line of case law. The one they particularly refer to is 31 of 18. And one can see right at the back of this tab, 1168, these are the questions that they've referred to the enlarged board. And the first one is framed in terms of exceptions to the principle of free evaluation of evidence. And then they say, if the answer to one is yes, can you take the post-published evidence in consideration on the basis that it's on the basis of ab initio plausibility, and 3 is on the basis of ab initio implausibility. So they're setting out those two lines of case law in their questions. Now, if we then go to tab 29 of the bundle, we find the enlarged board. And when we get to the end of the decision, we will see that the enlarged board themselves acknowledge that the answers it gives are rather abstract. And one sees that right at the end of 1363, paragraph 95. And in part, that is because they are trying to give answers that cater for all types of case, arising in, say, in different types of technical field, and not just pharmaceutical field, and including cases, as we'll see, where it's necessary to reformulate the objective technical problem. So they're trying to give an answer that addresses all those different possibilities, and that's why they end up with, as they say, rather abstract considerations. Now, the reasons start at 1319 bundle, and the first passage I was going to refer you to was on page 1323, which is where they're considering whether the reference is admissible. And there are various points were taken on that, but the one I want to show you is paragraph 18, which is, there was one of the parties making observations to the enlarged board, questioned the referring board's assumption of divergency of the case law, and argued that by its perception that the Board of Appeal applied the case law consistently and on the basis of the technical evaluation of the facts of the case in question. Now, and then they end up saying that it's admissible, but the reason is significant because we see this coming through later. The enlarged board accepts the referring board's perception of divergences in the case law, if only for the use of different conceptual and terminological approaches underlying questions 2 and 3. And they then say, confronted with those approaches, they felt unable to arrive at a clear conclusion. So the reason they accept divergence, but only really because of the terminology that's being used. And as we'll see, in the end, they say that these two lines of case law can be harmonised. Then we see paragraph 21. They point out that these questions arise in the context of examining inventive step. And then in 23, according to the established jurisprudence of the Boards of Appeal, the assessment of inventive step is to be made at the effective date of the patent. And that's the filing date, or if appropriate, the priority date. At the effective date of the patent, on the basis of the information in the patent, together with the common general knowledge then available to the skilled person. So that's the base on which one has to assess inventive step. And that's basic stuff, but it's important to remember that they have reasserted. Then they set out the problem solution approach, which they express slightly differently to the referring board. And then they say in 25, the technical problem, so this is the technical problem for the purpose of the problem solution approach, must be derived from effects directly and causally related to the technical features of the claimed invention. An effect could not be validly used in the formulation of the technical problem if the effect required additional information not at the disposal of the skilled person, even after taking into account the content of the application in question. Again, this is all basic stuff, but again, important that they have reaffirmed it. So you can only look at technical effects on the basis of the information content of the application read through the eyes of the skilled person. Then they go on to consider the principle of free evaluation of evidence. We don't need to trouble ourselves with that, apart from just picking up, when we come on page 1334 to what they call their intermediate conclusion on this area, they say, effectively in 55 and 56, you can't exclude evidence purely on the basis that it's post-published. But then they say, well, that doesn't mean we can just answer question 1 in the negative and not go on to questions 2 and 3. They say this in 57. The gist goes beyond the literal wording. And then in 58, they say, well, maybe I can just ask my lords to read 58 and perhaps also 59, and I'll make some observations on it. Now, what they're making, the point they're making here, one of the points they're making here is that plausibility is often used, as they call it, as a generic catchword. But the concept behind it is a criterion for the reliance on a purported technical effect. It's not a distinct condition of patentability and patent validity itself. And that, we say, is entirely in line with the way that the law is developed in this jurisdiction. It's recognised, for example, in Warner-Lambert, paragraph 36. We quote that in our skeleton. Plausibility is not a distinct condition for validity itself. It is a criterion for reliance on a purported technical effect. And because the question is, of course, whether what is claimed involves an inventive step, these are the statutory questions, whether what is claimed involves an inventive step and is sufficiently disclosed to, as the EPO would put it at the disposal of the skilled person. Plausibility is a criterion in the assessment of those two statutory questions. Then in 60 to 63, they have something called general. So they're now looking at jurisprudence regarding the reliance on a technical effect for inventive step. And they're going to talk about the EPO jurisprudence on that. There's some what they call general considerations, which are just quotes from some cases, which I don't think we need to look at. And then they go on 1337 to a section on analysis of the case law. And what they are, they point out there are lots of cases, and they're not going to look at all of them. And they start off by acknowledging in 65 the Type 3 case law, T31 of 18, but they pass over that pretty quickly and go on to look at the Type 1 and Type 2 case law. And we see that 1338, they talk about Type 1 case law, which is ab initio plausibility, that category coming from the referring board. And what they do is they go through various cases. And I'm going to come back to some of them in a moment, if I may. You see them set out here on pages 1338 through to 1343. And then they talk about Type 2 case law, 1343 through to 1347. And what they're doing here is they're identifying passages that they regard as significant in each of these decisions. And in some cases, they provide bold highlighting in order for us to see which bits they regard as particularly significant. And then we come at page 1347 to their intermediate conclusion. And they say, they take note of the classification done by the referring board. So that's into Type 1, Type 2. And then they say in 71, when analysing the case law in more detail, irrespective of the conceptual terminologies, what questions 2 and 3 refer to as two distinct plausibility approaches, the enlarged board understands from the case law of the boards of appeal as common ground that the core issue rests with the question of what the skilled person with the common general knowledge in mind understands at the filing date from the application as originally filed as the technical teaching of the claimed invention. And then they say applying that to the decisions, not reviewing them in an attempt to test the enlarged board's understanding. The enlarged board is satisfied the outcome in each particular case would not have been different from the actual finding of the respective board of appeal. Irrespective of the use of the terminological notion of plausibility, the cited decisions appear to show that the particular board of appeal focused on the question whether or not technical effect relied on was derivable from the person skilled in the art from the technical teaching of the application documents. So what they're doing here is saying they're trying to avoid the terminology of plausibility. What they're saying is that each of these decisions, what the board is doing is looking at the what the skilled person understands from the application as filed as being the technical teaching, and whether the technical effect is derivable from that technical teaching. And so we say what they're doing is saying something which differs in terminology rather than in substance. And we see, in fact, the same synthesis of different lines of TBA case law from in Warner-Lambert, because the assumption considers Johns Hopkins, Desatinib, and Ibsen, amongst others, which are categorised on different sides of the of the line by the referring board, that he sees them as all illustrating the same fundamental principle, namely that the patentee needs not only to make, but to disclose a contribution to the art. And this is what the enlarged board is saying. You have to look at what the technical teaching is and whether the technical effect is derivable from it. And with that in mind, I want to go back, if I may, to just see how...
Well, before we do that, I think it might be useful just to take a larger view, because, as you will be aware, what the enlarged board does in the next section of the judgment is to go on and look at it through the different prism of insufficiency.
Yes.
And having reviewed the case law on insufficiency, it reaches another intermediate conclusion at paragraph 77.
Yes.
Where it says the scope for reliance on post-published evidence is much narrower
Yes.
in the context of sufficiency
Yes.
than in the context of inventive step.
Yes.
And one of the things that I would be grateful for assistance on is what relevance, if any, that has for us in circumstances where, as I pointed out to Mr. Alexander yesterday, and he confirmed, that it was common ground between the parties at trial, that it didn't matter whether you were looking at it through the prism of obviousness or the prism of insufficiency. The answer was the same. And neither party has suggested to the contrary on appeal.
Yes.
So what then do we do with what the enlarged board has said? I mean, it may be that it's simply a problem for another day and that's all there is to it. But perhaps you'd like to think about that question over the short adjournment.
Yes.
And
I was going to address that with my lord. I'm not ducking that. I was going to deal with that.
fine, but it might be convenient to deal with all of that together.
Yes, and what I was going to do is to look at what they said about inventive step and go through that, and then come back to what they say about sufficiency, because obviously this is a reference about inventive step, and they look at the TBA case law, the national case law, and then they go on to their ultimate conclusions. And then I was going to come back and look at what they say about sufficiency, if that's convenient.
Certainly, very good. But I don't think we're going to be able to do that in 2 or 3 minutes. So
No.
let's pause there and resume at 2 o'clock.
All right.